I'm really happy to be here today. It's quite exciting to see so many excited faces and enthusiastic faces about blogging. And I suppose my main job today, in fact, just now before the session started, I was talking to Mr. Sean Ang outside from Malaysia, and he will be talking to you afterwards, giving you, I think, what he calls guerrilla tactics on how to avoid the law. My job is not to teach you to avoid the law. The law school wouldn't be very happy if I tried to do that. My job is to really alert you to what the possible legal pitfalls might be when you go about doing your blogging and so on, right? So what I will try to do is to cover the subject in 4 headings. Of course, what I'll try to do is I'll try and finish it off, and then we can do questions later, if you don't mind. Of course, if you think the question can't wait, I'll try and answer them quickly. But if I can't answer it quickly, I will defer it towards the end. Okay. Right now, I will cover 4 main areas. The first area, defamation. Second, contempt of court. Third, something called sedition. And finally, copyright violations. Now, it is quite interesting that, as Sharon pointed out, that we have co-taught media law and ethics in NTU for several years. And it was only this year that NUS ran the very first media law course. And so media law, although a fairly important topic in most law schools around the world, doesn't seem to get that much attention in this part of the world. I have no idea why. But let us take on defamation. I begin by looking at the words of the Singapore Constitution. We always begin with the Constitution because that sort of circumscribes or guarantees to us these liberties that we are supposed to have. And the relevant article is Article 14 of the Constitution, which says, this is a classic case of giving with one hand and taking back with the other hand, right? Every citizen of Singapore has the right to freedom of speech and expression, but it is not absolute. One of the favorite last words of our courts and our policymakers is that nothing is absolute, it's always been balanced and so on. And so we balance it in Article 14(2)(a) by saying that Parliament may by law impose such restrictions as it considers necessary or expedient in the interests of the security of Singapore or any part thereof, friendly relations with other countries, public order or morality, and restrictions designed to protect the privileges of Parliament or to provide against contempt of court, defamation, or incitement of any offence. I have coloured the words contempt of court and defamation because these are the ones being covered in this morning's session as well. But I want you to take note also of the certain words given here. This is something which unfortunately people don't pay enough attention to. We know that the Constitution does give us liberties, and the government can have grounds to take them away. But there are very specific grounds for taking away liberties, if at all. And they are friendly relations with other countries. In other words, if you start a blog starting to attack Malaysia and saying that we can never be friends with Malaysia, the new prime minister is an idiot, blah blah blah. Yeah, I guarantee you will be shut down. Okay, there will be a problem. Okay, because this jeopardizes our friendly relations with our neighbors. Public order, usually cast very broadly, but there is a certain suggestion that in order for you to be having your liberty circumscribed on account of public order, there must be some endangerment to the public in some way, right? And then privileges, morality, right? Obviously, if you start a porn site, there will be a problem, all right? But I think it's not just pornography, there's more to that, right? So anyway, this is where our starting point is. Now you will know that Article 14 recognizes the law of defamation. Now in a jurisdiction like Singapore, just like many of the former British colonies, just like in England, the law on defamation is what we might call a common law subject. A common law subject is one which is developed by the courts. In other words, it's unlikely that you can go to one place and find the law written down in a particular act of parliament. Now we do have something called the Defamation Act. But the Defamation Act does not give you the test for defamation. It merely tells you what happens in certain instances of defamation, what happens if there's innocent defamation, what happens if you offer to make amends, and so on. It does not tell you what constitutes defamation. does not tell you, oh, when do you cross the line. That is a subject that's been developed over time by the courts, right? And because it's what we call a common law subject, i.e. developed by judges over time, adapting to changing circumstances, the common law system is considered to be a rather more flexible system which allows judges to take into account, right, changing circumstances. Right? So, yes, as I pointed out, there is a Defamation Act, common law of defamation under a subject in law which we call torts. I know tort is also something that you eat, but not in this particular case. Now, as I pointed out, the Defamation Act does not deal with the test of defamation, but only with defenses and remedies. And so we have to go to the common law. We've got to go to a classic case to find out what the test of defamation is. When someone says you have defamed me, what exactly does that mean? The classic test is given in a House of Lords decision in a 1936 case called Sim and Stretch. Lord Atkin, whose little portrait you see here, he said, a statement is defamatory if it tends excuse me, to lower the claimant in the estimation of right-thinking members of society generally. So there's several elements in it. Number one, it must lower the claimant in the estimation. Right? In other words, whereas you used to think he was here, you now look at him as below that. Now, but where's the here? What is the benchmark? The benchmark is that of right-thinking members of society generally. So obviously you don't take the test of lunatics, you don't take the test of rabid right-wingers, no, you take the test of the average man. What the English very, very nicely call the man on the Clapham omnibus, right? The regular guy, right? Maybe in Singapore context, I mean, of course this has never appeared in any judgment, okay, but I imagine if you want to translate this into Singapore speak, might be, in the estimation of the right-thinking HDB Heartlander, or something like that. But anyway, you're looking at a reasonable man, a fictitious character out there. So long as I have lowered you in the estimation of such people, that constitutes defamation already. Now, in order for you to succeed in defamation, the claimant must show two things. First, that the statement identifies or refers to the claimant himself. Right? I cannot be sued for defamation if I say, oh, those guys are all corrupt. Those guys, who are those guys? Right? Or if I say, bloggers are a whole bunch of idiots, no one can sue me for defamation. Because I have not pinpointed any particular person such that you can be seen as being lowered in the estimation of others. Right? So the identity part is very important. Okay? So this is maybe one of the things that you can bear in mind, that if you do it generically, chances are you are not going to be defaming any particular person. The second requirement is that it must be published to a third party. Alright? I can call you the worst, most horrible, heinous names in your face, and there's no defamation because nobody else is there to hear it except you. And that's not defamation because there's nobody to think about it except you. You follow? So there's no defamation. Of course, if it's published simply means that it has been heard outside. Now, of course, I'm not going into the technical details because, I mean, what I'm trying to summarize in this short period, we usually take a whole term to teach. We make a distinction between libel and slander, and really there's not a whole lot. For bloggers, it will always be libel because you're blogging and it's published, it's written. Slander is when it's spoken, right? Yeah. Now, the test of whether a statement is defamatory is an objective test, and there are certain established categories that have been throughout time that accepted as definitely as being defamatory. Okay, if you impute some kind of bad character, some kind of lack of morality on the part of an individual, that automatically means it's defamatory. If you also impute a lack of professionalism, some kind of moral turpitude that you can't trust this guy with money or things like that, that is also regarded as one of the categories of being defamatory. I've chosen to give two little illustrations here to show